Hello and welcome to the 30 Years, 30 Cases, a series of video podcasts launched by the Academy of European Law ERA to mark its 30th anniversary. My name is Nataša Vujnović. I'm a course director in the business law section of ERA. The podcast series address landmark cases of the European Court of Justice for each of ERA's 30 years of existence. This podcast is dedicated to the judgment of the court, which dates back to June 16, 1998. It is the case C-53/96, widely known as the Hermes case. The case will be revisited and its importance as a landmark judgment of the Court of Justice addressed by our guest expert, Professor Jacques Bourgeois. Professor Bourgeois is a professor at the College of Europe, a guest professor at the University of Ghent, as well as senior advisor at Sidley Austin LLP in Brussels. He has extensive experience in representing clients before the European Commission, the Council of EU and other EU institutions, as well as before the European courts in Luxembourg and Belgian courts. Prior to entering private practice, Professor Bourgeois served for over 25 years as a senior official with the European Commission. He was also visiting professor at the University of Michigan Law School and Jean Monnet professor at the Universität Bonn. He taught at the Universitat Autónoma de Barcelona, the World Trade Institute, and the St. Gallen Hochschule MBL program. Professor Bourgeois, it's a pleasure to have you elaborate on the Hermes case.
As is often the case, a judgment such as Hermes raises several issues. But I'm going to limit myself to one single issue, that of the competence of the then European Community to enter into an international agreement, more specifically the TRIPS agreement, trade-related aspects of intellectual property resulting from the Uruguay Round. I am going to address the Hermes case as such, and then two further developments in the same area. So, the origin of the case, ladies and gentlemen, well, the origin of the case is very simple. It's exactly this. Why is it this? Well, the judgment of the Court of Justice is a judgment replying to a request for preliminary ruling, and this request of preliminary ruling was submitted by a Dutch court. By a Dutch court in the framework of a request for interim order. A request for interim order brought by Hermes against a company in the Netherlands called FTH, and Hermes accused that company, FTH, of infringing its trademark right and its copyright in connection, again, with this sort of thing. And the Dutch judge was confronted with a discrepancy between the Dutch rules on civil procedure for interim measures and the rules contained in Article 50 of the TRIPS agreement, and raised the question to the Court of Justice. I'm going to quote it, abridged. Does an interim measure, as provided for in Article 289 of the Dutch Code of Civil Procedure, fall within the scope of provisional measures within the meaning of Article 50 of TRIPS? This question was raised against a very interesting background. And the background dealing with the law of external relations of the European Community, as clarified by the Court of Justice in its famous opinion 194 concerning the conclusion by the European Community of the results of the Uruguay round. One of the agreements of the Uruguay round being precisely the agreement on the trade aspects, commercial aspects of intellectual property. And in that opinion, 194, the court had first found that intellectual property right does not fall within the scope of the common commercial policy of the then European Community. And secondly, that the European Community and its member states are jointly competent to conclude TRIPS. And in that opinion, 194, it considered that with respect to the TRIPS agreement, the EC had no exclusive external competence under the so-called IETR doctrine, as the EC had not, at the time of opinion 194, exercised its internal competence in that particular field. It's interesting to note that this Dutch court has no doubt whatsoever, A, that the Court of Justice of the European Community has jurisdiction to interpret the TRIPS agreement, and secondly, has no doubt that individuals may rely on the TRIPS agreement in proceedings before a national court. Member states intervened in the proceedings in the Court of Justice. 3 member states intervened. And the Council of Ministers intervened. And they essentially claimed that the court has no jurisdiction whatsoever, because they say the TRIPS provisions are not provisions that are within the EC's competence to conclude an international agreement. The Advocate General Tesauro thought that the obligation to cooperate between member states and the European Community and the requirement of unity of international representation of the European Community justify that the court interprets the TRIPS agreement. What did the court do? Well, on its jurisdiction, the court found that when the TRIPS agreement was concluded by the EC and the member states, there existed already a EC regulation on the community trademark, which regulation contained provisions on interim measures, which meant that on the basis of the IETR doctrine, as a result of this regulation, the European community had exclusive external competence. On direct effect, the parties, the interveners, and the member states, and the Advocate General had debated the issue. The court did not touch it. Did not touch it by simply noting that the referring court, the Dutch court, had not put a question to the Court of Justice on the direct effect. This was a situation when two further developments occurred. The first one of these further developments is the Daiki Sankyo judgment of the Court of Justice, C-1411, of 18th July 2013. And I think it's interesting to refer to that judgment because one of the questions raised, submitted to the court in this Daiki Sankyo judgment was in fact the same as in Hermes. The EC competence and the direct effect of the relevant provisions of the TRIPS agreement. However, there was a very important difference. The relevant EC treaty provisions under which in Hermes the European Union had concluded the TRIPS agreement, Article 113 European Community Treaty, have been replaced in the meantime by Article 207 of the Treaty on the Functioning of the European Union. And this Article 207 contains a provision including within its scope, i.e. the EU commercial policy powers, the commercial aspects of intellectual property protection. So consequently, one could say, well, there is no longer an issue of the TRIPS agreement being considered as an act of the European Union and consequently being able to be interpreted by the Court of Justice of the EU. Well, the court has pointed out that the TRIPS agreement is to be considered as an act of the European Union insofar as it concerns the commercial aspects of the protection of intellectual property. Which then raises the question, yes, but what are the commercial aspects of the protection of intellectual property? Well, the court points out that only those aspects, only those provisions of the TRIPS agreement that have a specific link to international trade are capable of falling within the concept of commercial aspects of intellectual property in Article 207 of the Treaty on the Functioning of the European Union. And the court came to this conclusion, to the conclusion that this applied in this case, because it pointed out that the TRIPS agreement is integral part of the WTO system, which is a system precisely designed to regulate international trade. Secondly, the dispute settlement system of the WTO allows taking countermeasures for violation of TRIPS, take countermeasures in other areas, notably in the areas of trade in goods. And thirdly, there is no secondly, these are two essential elements on which the court relied. Here again, interestingly, the issue as to whether Daiki could rely on the TRIPS agreement in a court of a member state was not dealt with by the Court of Justice. And the explanation is that the Greek court raised the question of direct effect only where the Court of Justice would consider that Article 27 of the TRIPS agreement comes within the field for which the member states continue to have primary competence. As the court decided that the EU had primary competence, the court did not have to reply to this question either. This was the first development subsequent to the Hermes case, to which I want to draw your attention. The second development of interest, or the question of the external competence of the EU and the jurisdiction of the Court of Justice with respect to intellectual property protection. The second one is opinion 215 of the Court of Justice on the EU-Singapore Free Trade Agreement, which is an opinion of 16 May 2017. It's a fascinating opinion. It was rendered by the full court, which very rarely happens. And it's a very extensive opinion because it covers the whole of the free trade agreement between the EU and Singapore, covering a whole series of areas. I'm going to address only the area of protection of intellectual property. Before I do this, let me point out that in this case, 25 member states intervened, plus the Council, claiming that certain provisions do not fall within the EU's exclusive external competence. The agreement having the characteristics of a mixed agreement. And the member states claimed the provisions on intellectual property in the FTA agreement between the EU and Singapore, on which the Commission had sought the opinion of the court, do not present a specific link with international trade. What did the court do? Well, with respect to this particular issue, the court repeated the position it had taken in Daiki Sankyo. And I quote, international commitments concerning intellectual property, abridged, fall within those commercial aspects where they display a specific link with international trade, in that they are essentially intended to promote, facilitate, govern such trade, and have a direct and immediate effect on it. End of quote. That is to be found in paragraph 112 of that opinion. And the court notes that the relevant provisions of the EU-Singapore Free Trade Agreement state that they seek, and I quote, to facilitate the production and the commercialization of innovative and creative products and the provision of services between the parties, and to increase the benefits for trade and investment. Is the first element on which the court relies, and the second one, in light of the key role of protection of intellectual property in trade, in goods and services, it must be accepted that these provisions of the EU-Singapore Free Trade Agreement on intellectual property are covering the commercial aspects of intellectual property protection. If there is a conclusion to be drawn, I think the first one is really, or the only one, is that there is a remarkable development on the external competence of the EU, progressively passing through progressive building blocks. From Hermes, relying on the ITR doctrine, to Daiki Sankyo, after the Lisbon Treaty had included protection of intellectual property within the scope of the common commercial policy. And finally, Opinion 215, again rendered, I repeat, rendered in full court, confirming the concept of commercial aspects of intellectual property. There are still some questions outstanding, but they will come up, and we will see what the court will say about that. Thank you very much.